You know what, friends? Judges often get it wrong, but they don't usually get it lawless.
No, Glenn. They get it lawless all the time. You just don't see it because, as a career prosecutor, you have literally spent your whole life constantly sucking the government's dick. In fact, I guarantee that you personally have been party to at least a portion of this corruption in your career and have actively participated with your own hands in covering it up. What's up, guys? Acer Thorn here, and this is Purple Politics. The rule of law. Stare decisis. Binding precedent. We frequently hear these platitudes come out of judges' mouths, but what exactly does any of them mean? Does it even really mean anything at all, or are they just empty platitudes that are just there to give the illusion of honor and integrity in our justice system, without there actually being any honor and integrity? So what exactly is binding precedent, also known as stare decisis? Well, put simply, it's supposed to mean that trial court judges are supposed to follow case law set by their superior courts, and that courts of appeals are likewise supposed to follow case law set by the Supreme Court. Published cases that come from the appellate court of the circuit the district court is located in are considered binding precedent, while any cases that come from other circuits, any cases, published or unpublished, that come from any district courts, as well as any unpublished cases, even if they come from the appellate court of the circuit that the district court is in, are all considered persuasive precedent. Now, the difference between binding and persuasive precedent is that when it's binding precedent, the district court must follow the precedent whenever it is applicable to the case at hand. Whereas with persuasive precedent, the district court can follow it in any given case if they want to, provided it isn't in direct contradiction to binding precedent, but they don't have to follow it. Or at least, that's how it's supposed to work. In practice, however, there's really no practical difference between binding precedent and persuasive precedent. Think about it. What exactly does it mean for something to be binding? Judges and lawyers will often tell you that this means that the judges must follow that precedent, but what exactly does must follow mean? Now, here's a challenge for you. Pause the video before you watch the rest of it, and call up literally any lawyer or judge who will agree to talk to you and ask them that question, but without any of the additional context I am about to provide. Chances are they will be utterly perplexed by this question. They'll look at you like you're speaking a different language. What exactly does must follow mean? Well, what do you mean by that question? Must follow means must follow. Duh. Now, I don't know about you, but for me personally, when there's something that somebody must follow, I usually interpret that to mean that there are some kind of consequences for the bound person if he doesn't follow it. Maybe not jail time, and maybe not even removal from office, since it's pretty well established that nothing short of impeachment can do that to a judge. But if a judge fails to follow binding precedent, he should be subject to some sort of punishment from his superiors, right? Otherwise, what's the point of saying that he must follow that precedent? So I ask you, what exactly is the penalty for a judge if he fails to follow binding precedent? Put simply, there is none. I don't simply mean there's a de jure penalty that exists on paper, but which in practice is rarely, if ever, applied. No, I mean there is no provision, even on the books, for actually punishing any judge who fails to follow binding precedent. Each federal court of appeals has a Judicial Discipline and Disability Commission, which has the power to discipline judges for misconduct, except there is an exception written in the plain text of the statute that says that they cannot punish a judge for any misconduct that directly relates to the merits of the case he was deciding. In other words, blatantly ignoring binding precedent and simply deciding the case how he wants to decide, simply because he's decided that one party is a doo-doo head, is exempt from punishment. Now, many a lawyer and many a judge will try to save face on this matter by telling you that the appropriate remedy if a trial judge blatantly violates binding precedent is to file an appeal. If the trial judge has indeed ignored binding precedent, then the Court of Appeals will overturn the judgment. However, this is, honestly, a joke of a remedy in the best case scenario. First of all, if there's nothing practically forcing trial judges to follow binding precedent, then what makes you think there's anything practically forcing the Court of Appeals to follow binding precedent? It's all a bunch of handshake agreements with no real enforcement mechanism in place if everyone in the judiciary just randomly decides they don't like a particular person and they just spontaneously decide that the rules don't apply to this one person. But even barring that, that just returns us to our old question. What exactly is the difference between binding precedent and persuasive precedent? Remember that if you offer persuasive precedent in the trial court and the judge rules against you, you still have the right to appeal that too. Then you can hope for the best that the Court of Appeals will decide that they're going to follow the foreign precedent from now on and overturn that judgment. Then that would become binding precedent, assuming the opinion is designated for publication, but again, that distinction means nothing as a practical matter. So if the judge disregards persuasive precedent in your case, you have the right to appeal that judgment and hope for the best. If the judge disregards binding precedent in your case, your remedy is to appeal that judgment and hope for the best. So when I ask you what the practical difference is between the two, the answer is absolutely nothing. This, in turn, means that there might as well not even be such a thing as binding precedent. What's the point of distinguishing between the two if there's no practical difference? So, some of you may understandably be wondering right now, exactly how common is it for judges to act in blatant disregard to binding precedent just because they can? And the answer is more often than you could possibly wrap your head around. According to the Yale Law Journal article, Corruption in Our Courts, What It Looks Like and Where It Is Hidden, it is estimated that there are over 1 million judicial bribes each year. And before anyone thinks I'm cherry-picking the most alarming stat, I'm actually not. This is actually the lowest estimate I was able to find from a credible source. I found sources that heavily imply the number of annual judicial bribes to be as high as 15 million a year. Anyway, if this report were accurate, which I assume it is, since an institution as prestigious as Yale would almost certainly not allow something to be published under its name that hasn't been fact-checked 11 ways to Sunday, that means that a bribe occurs in this country an average of 1.9 times per minute. Not per hour, per minute. Now, some of you might reasonably ask, if the corruption is this rampant, and the evidence for this corruption is so well documented that even Yale will allow it to be published under their name, how do judges get away with it? And the answer is, with an iron fist. That's how. Judges can and routinely do persecute and punish anyone who dares to speak out against them. Lawyers who speak out against judicial corruption are especially vulnerable, since it is generally understood that they sign away a portion of their First Amendment rights as a condition for being granted a law license. Of course, that's still fucked up even then, since lawyers are in the best position to notice the corruption and report on it. It's still blatant whistleblower retaliation. But even barring that, you don't even have to be a lawyer. Even private citizens often find themselves on the receiving end of a judge's wrath if they dare criticize that judge or call him corrupt. Often, they'll make no effort to hide the fact that it's blatant retaliation. They'll often admit to it out loud. Because why shouldn't they? There are no consequences for doing this. It's not like they'll get punished for it. You can't sue them for it, even if it was blatantly corrupt and blatantly unconstitutional. They have absolute immunity from suit, and by God, they take full advantage of it. Yeah, because nothing says totally not corrupt quite like an institution that will stamp down on anyone who dares to call it out on its corruption, even when the accusations are made in good faith and even when there's absolutely no proof that the statements are false. On an unrelated note, why, yes, officer, I did beat the shit out of my girlfriend just now. What do you expect? She was spreading false rumors about our friends and family that I was abusive. Honestly, what did she expect to happen when she starts spreading such horrible lies about me? Of course, I said at the beginning that Glenn Kirschner is party to this corruption. That's because he's a federal prosecutor, or at least a retired one. Judges are some of the most corrupt sons of bitches in the entire American government due to the fact that they are supposed to be in charge of the courtroom and have a duty to uphold the law more than any other officer of that court. But frankly, prosecutors are honestly not a whole lot better. Many a prosecutor will do anything, and I mean just about anything, for a guilty verdict, including suppressing exculpatory evidence to blatantly misstating the law to the jury, which is supposed to be the judge's job anyway, to even using testimony they know full well to be perjured. As Peter Joy, writing for the Wisconsin Law Review, states, they have prosecuted black men hiding evidence the real killers were white. They have prosecuted a wife hiding evidence her husband committed suicide. They have prosecuted parents hiding evidence their daughter was killed by wild dogs. They do it to win. They do it because they won't get punished. They have done it to defendants who came within hours of being executed only to be exonerated. Hell, sometimes they do it to people who have already been executed, only for the prosecutorial corruption to be exposed after the defendant is already dead, and they still don't get punished for it. Prosecutors getting punished is exceptionally rare. In a study taken over the course of 50 years, there were 3,625 identified cases of prosecutorial misconduct. Not 3,600 complaints against prosecutors, because I guarantee you a hell of a lot more than that were filed for the entire country over 50 years. I'd be surprised if one state had that few complaints filed in a single year. No, we're talking 3,625 cases of confirmed prosecutorial corruption, and more than 98% of them resulted in no punishment whatsoever against the prosecutor, not even so much as a slap on the wrist. At least if the allegations of corruption were found to be meritless, I could understand the prosecutor not being punished then. But again, we're talking about confirmed cases of corruption. Oh, and in the already rare case where a proven instance of prosecutorial corruption resulted in any punishment at all, only 14 cases, less than 0.4%, resulted in anything more than a slap on the wrist. I assure you that Kirschner has personally participated in at least some of this corruption. Given how many cases he has prosecuted over the years, given how widespread prosecutorial corruption is, and given how astronomically rare it is for corrupt prosecutors to be punished for their corruption, it is a foregone conclusion that at least a few of the cases he prosecuted had him bending the rules at least a little bit in order to get a guilty verdict, even if the percentage of cases he handled where he did that was extremely low, which I doubt. Given the sheer number of cases he has handled over his entire career, the flat number of cases where he personally engaged in a little evidence tampering is certain to be a pretty big flat number. Of course, Kirschner is certainly not going to admit to any of that out loud. He's probably going to insist that he is a saint of a prosecutor. But here's one challenge I can issue to Kirschner that, unless he ignores it completely, he'd have no choice but to admit that he is indeed party to the corruption in our justice system. I want everyone watching this to send this challenge to him. Make sure he doesn't forget that his silence in response to this challenge is tantamount to an admission of guilt. Glenn Kirschner has said on his channel before that at least a few police officers are indeed corrupt, and that this corruption taints the justice system.
You hear them yelling at Tyree to comply, comply, while ironically, the officers themselves are not complying with anything that approaches proper police procedures, or for that matter, with anything that displays even a shred of humanity or concern for a fellow human being.
So here's my challenge to you, Mr. Kirschner. In your 30 years as a federal prosecutor for the District of Columbia, there had to have been at least a few times when a case you were prosecuting was found by you to be tainted with police misconduct, if not outright police corruption. You say the vast majority are in it for the right reasons, but even if the percentage of bad cops is extremely low, and I'll get to that in a minute, again, given the sheer number of cases you've prosecuted over the years, it is a foregone conclusion that at least some of them were tainted by bad cops. So I ask you, Mr. Kirschner, in the admittedly rare event that you discovered that a case you were handling had been so tainted, how many times did you not only dismiss the charges against the citizen who was falsely accused, but then turn around and proceed to charge and prosecute the corrupt cop for his corruption? Simply dismissing the first case isn't good enough, because as we've already established, that is a joke of a remedy when the offending party isn't also being actively punished himself. If, in fact, there are even a handful of cases where you did the latter and ensured the cop was held accountable for his actions, then there should be federal court records of you doing this, meaning you can't lie about having done it. However, if you cannot show any instances where you prosecuted the corrupt cop, and I don't think you can, then that means you have no right to claim you are any better than all of the worst cops, judges, and prosecutors out there. You're just as bad as those who actively contribute to the corruption with their own hands. And just for the record, I highly doubt you can produce any instance where you charged any corrupt cops, because if you did, you almost certainly wouldn't have had such a long and successful law career, and you almost certainly wouldn't be enjoying the cozy retirement you're currently enjoying. If you had actually done everything in your power as a prosecuting attorney to actually lay down the law and actually hold those corrupt cops to genuine account, you would have long since been outed as a snitch and as someone who doesn't play ball with the establishment long before you were able to afford such a cozy retirement. People like disgraced lawyer Richard Fine and disgraced police officer Paul Manning have had their livelihoods stripped from them because they actively fought back against the corruption, and they paid the price dearly. If you were even a tenth as honorable as you claim to be, you would have long been outed by your comrades, just like they were, as someone who wasn't willing to play ball. The only way you could have had such a long and successful law career culminating in such a cozy retirement is if you were actively playing ball with the corrupt establishment, or at the very least complacent in it. Either you were actively participating in the corruption yourself, or at the very least you were actively keeping your head down and refusing to actually do anything to fight back against the corruption, despite absolutely having the power to do so, at which point you're still part of the problem. So there you have it, ladies and gentlemen. In reality, there is no rule of law. It can be suspended on a case-by-case basis on a whim, whenever anyone with power decides it doesn't apply. Judges, police, and prosecutors frequently ignore the law in flagrant and blatant ways, ruining lives and destroying families simply because there are no consequences for them doing so. Anyone like Glenn Kirschner who tries to tell you otherwise is a bald-faced liar, or at the very least have lived their whole lives in the corruption to such an extent they no longer notice its stench. So that was my take on the myth of the rule of law. If you enjoyed this video, regardless of whether you agree with my opinion or not, be sure to subscribe for more Purple Politics videos. Once you've done that, check out my featured video for returning subscribers, for ways you can support the channel through monetary donations on my Patreon, as well as over at my main channel. In the meantime, however, I am Acer Thorn, and this has been Purple Politics.